Item 5, Sri Vivek Sharma, Sri Mayank Chandrakar.
May it please your lordships. Lord, I'm challenging the validity of section 17A, in particular the proviso to section 17A of the Chhattisgarh Madhyastham Adhikaran Adhiniyam 1983. I think a copy of the Act has been filed along with the petition. Would your lordships kindly have the Act?
Yes, Mr. 17A.
Yes, 17A, first proviso in particular.
Probably that prohibits the power of the arbitral tribunal to grant interim award. Yes.
To prohibiting the arbitral tribunal from granting any order of injunction, stay or attachment. Now that I'm challenging on 3 grounds. One, it is discriminatory. Second, it is manifestly arbitrary. And third, for the purposes of the Act, this is not a proportionate remedy. I'll tell your lordship the reasoning which I want to submit. This Act is broadly on the same lines as the Arbitration and Conciliation Act. In fact, if your lordship will kindly see, Section 2, subsection 2 of this Act, the Arbitration Act.
Which has been annexed, no?
No, the Act has been placed, we filed a copy
That
of the
has
Act.
been subsequently filed, probably.
We have filed copies of the Act, but maybe your lordships will have the book. Of the Adhiniyam Act, the Chhattisgarh Act. It's otherwise on the same lines as the Arbitration and Conciliation Act.
Section 2 of the...
Section 2, subsection 2. Just to show, words and expressions used but not defined in this Act, but defined in the Arbitration Act, shall have the meanings assigned to them. So it's practically borrowing from the Arbitration Act. What it does is, it creates a class of contracts called works contracts. Please see section 2(1)(I). Works contract means an agreement in writing for the execution of any work relating to construction, repair or maintenance of any building or superstructure, etc., etc. I'm skipping those words. Powerhouse, transformers, or such other works of the state government or public sector undertaking as the state government may by notification specify in this behalf at any of its stages entered into with the state government or by an official of the state government or public undertaking or its official for and behalf of such public undertaking, and includes an agreement for the supply of goods and material and all other matters relating to the execution of the said works. Now, public undertaking has been narrowly defined as, in 2(1)(g), public undertaking means a government company within the meaning of section 617 of the Companies Act, and includes a corporation or other statutory body or whatever name called in each case, owned or controlled by the state government. So this Act, my lord, carves out an area called state government owned or state government PSU owned undertakings, works contracts as defined, only for those contracts. Now for those contracts, they constitute a special tribunal under section 3. I have no quarrel with that. Section 3 of the Adhiniyam Act, a special tribunal is constituted. I have no problem. Now kindly come to section 7. This is the sting in the tail. Either party to a works contract shall, irrespective of the fact whether the agreement contains an arbitration clause or not, refer in writing the dispute to the tribunal. Miller, in the Arbitration Act, only when there is an arbitration agreement, the Act will apply. If there is no arbitration agreement, your lordships may, in a suitable civil court, civil dispute, refer it. But nobody can mandatorily say, even if I do not enter into an arbitration agreement, I must refer it to the arbitral tribunal. Anyway, this is mandatory whether the works contract agreement contains an arbitration clause or not. Be that as it may. Now kindly come to section 17A. Well, all other sections, your Lordship may take it from me for the time being. Reference, limitation, procedure and reference, then power of tribunal, place of sitting are all broadly on the same lines as the arbitration. Now kindly come to 17A. Nothing in this Act shall deem to limit or otherwise affect the inherent powers of the tribunal to make such order as may be necessary for the ends of justice or to prevent abuse of the process of the tribunal. Very wholesome provision, but see the proviso. Provided that no interim order by way of injunction, stay, or attachment before award shall be granted. No interim order. Now kindly see section 20. As from the date of the constitution of the tribunal, and notwithstanding anything contained in the Arbitration and Conciliation Act or any other law for the time being in force, or in any agreement or usage to the contrary, no civil court shall have jurisdiction to entertain or decide any dispute of which cognizance can be taken by the tribunal under this Act. Now, this is the structure of the Act. Now, my facts are, I'm supplying equipment, balance of power equipment, to respondent 2, which is the Chhattisgarh
State Power Corporation Limited.
It's got a Hindi name, but in English it means Chhattisgarh State Power Corporation. I'm supplying. I have an agreement with them. It contains an arbitration clause, but it says arbitration under the Arbitration and Conciliation Act of 1996. Now, I want to arbitrate under that act, and I went to the Madras High Court under Section 9. Madras High Court said, in view of this Adhiniyam Act, we have no jurisdiction. You can go to the Chhattisgarh High Court, which is why I've come. And I have a matter before another bench of this Honorable Court on the merits of the matter. Now, you pick out one class of contracts, whether there is an arbitration agreement or not, and say whether there's an arbitration agreement or not, you shall refer it to this tribunal. Up to that, I may not have too much of a problem. You create a special tribunal, but interfere with what is, I would call, judicial power by saying that judicial tribunal cannot grant any order of injunction. Now, my submission is, if I went to a civil suit, I can get under Order 39, Rule 1. If I went under the Arbitration and Conciliation Act, I can get an order under Section 9. Or the court may say, I will pass an order for a limited period, go to the arbitral tribunal, you will get an order under 17. So I have 3 forums in which I could get an interim order, provided I satisfy the 3 tests: prima facie case, balance of convenience, and irreparable injury. That is being taken away. But if you create a special tribunal, it must be equally efficacious tribunal. You can't create a tribunal with lesser powers, limit the powers, and then say, sorry, all of you, whether you have an arbitration agreement or not, whether you have a right under Order 39, Rule 1, whether you have a right under Section 9 of the 1996 Act, whether you can go to the agreed arbitral tribunal in the 17, you have to come to me, but I will not grant you any interim order. The tribunal cannot grant you an interim order. Now, my lord, I said this is completely arbitrary, nothing to do with the purpose of the Act. Purpose of the Act is only for speedy arbitration. Purpose of the Act is speedy arbitration. Now, let me come down to the facts of my case. I am asking that a bank guarantee ought not to be invoked. Your lordships know, your lordships must have laid down only 2 grounds: fraud and irretrievable injury. Whether I establish those grounds is a different matter. But where I can prove fraud, where I can prove irretrievable injury, even then this tribunal cannot grant an injunction. How can this proviso be, in the light of the law that is being developed now, how can this proviso stand at all? Manifestly arbitrary, disproportionate, not proportional at all, and discriminatory.
You mean to say that this provision 17A takes away the right of the tribunal to grant interim relief.
Yes, because you're creating a judicial tribunal
Right.
to replace a civil court. You have to invest that judicial tribunal with all the judicial powers. It may or may not grant an injunction. That is left to the judge who's presiding. But you can't say, the legislature cannot say, I will create a tribunal, I will bar the jurisdiction of a civil court, I will bar an agreed arbitral tribunal, I will create a tribunal, you shall go before the tribunal, but the tribunal will not grant you an interim order. Well, this is manifestly arbitrary, and I've got...
My lord, this is an act of 1983 which has been incorporated, my lord. Under section 17A, where the inherent powers have been given, it is with regard to the injunction only. It's a speedy justice, my lord. This Arbitration Act, Madhyastham Adhikaran Adhiniyam, 1983. This came into existence only for the purpose of arbitration with respect to the works contract with the government. And for speedy disposal of those cases, this particular provision has been incorporated. Now, with regard to this particular, that no interim order by way of injunction can be granted, my lord. I'll file a detailed reply to that extent, that since this provision, how the object of
And
this,
in the meanwhile, don't proceed against them.
but for that they have already filed another petition before this.
They have filed.
Yes, yes,
Stay also.
Stay here.
Yes,
They have already.
Let them file the counter. You have a stay.
I'm not asking an interim order from your
Right,
lordship
right,
now. I can't ask an ex parte interim order of a provision of law. I'm only saying, please issue notice on the matter and let them file.
That we have to file.
Third, such and such. So if you want to file.
I am for one.
I'm for two.
You are for one and you are
I'm
for
for
two.
two.
The counsel for the state respondent such and the and respondent number 2 prays for allowed 4 weeks time.
Yes, ma'am.
To file a reply, file a return, and 2 weeks for rejoinder affidavit, and list the matter immediately thereafter. Party's name is
Is your lordship giving a specific date or?
after 6 weeks, Mr. Chairman.
After 6
After
weeks.
6 weeks.
Which will, some date in October, my lord?
Probably. Let the pleadings be completed, then you may
Very
address
well,
the court.
very well. Deeply obliged, deeply obliged.